Accused is facing trial for the offences punishable under sections 353, 504, 506 of the Indian Penal Code, in short IPC, and section 85(1) of Bombay Prohibition Act. Considering the oral and documentary evidence laid by prosecution and after hearing the submissions of rival sides, following points arise for my determination, and I record my findings thereon with reasons as under. Para. In order to prove the guilt of accused, the prosecution has examined total 5 witnesses. The particulars are as follows. Para. Besides this oral evidence, the prosecution has relied upon a FIR at Exhibit 15, Spot Panchanaama at Exhibit 26, and a medico-legal certificate at Exhibit 24. Para. It is the case of prosecution that on 20th November 2013 at about 4:10 p.m. at Karkali bus stand, the informant Ravina was working as a bus conductor on a ST bus bearing number MH02AB 1214, and PW2 was the bus driver. At that time, the accused assaulted with the informant, who was acting as a public servant in discharge of her duty as such public servant. The accused was under the influence of liquor and behaved indecently and in disorderly manner. He had snatched the ticket machine and thrown it away. He had also abused the informant and threatened her to kill. Para. The learned APP Sri Markad argued that the driver and bus conductor have deposed the incident in detail. He argued that the accused has admitted his presence at the time of incident. He has taken the defense that he was intending to keep the fertilizer sacks in the carriage on the roof of the bus. Therefore, as the accused has admitted his presence, he has to show probably that he was keeping the fertilizer sacks in the carriage on the roof of the bus, and there was only verbal scuffle with the informant. He argued that one independent witness, that is PW number 3, was traveling in the same bus, who has also supported the informant and the bus driver. He further argued that the medical officer had examined the accused and opined that the accused was under the influence of liquor. Therefore, the evidence laid by the prosecution is sufficient to hold the accused guilty of the offences punishable under section 353, 504, 506 of IPC, as well as section 85(1) of the Bombay Prohibition Act. Para. The learned advocate for accused Sri Save argued that the prosecution witnesses, that is PW number 1 to PW number 3, are interested witnesses and their oral evidence cannot be relied upon. He argued that the oral evidence of PW number 1 to PW number 3 suffers from many contradictions and omissions, which makes their evidence unworthy of trust. He argued that the oral evidence of investigating officer is also not trustworthy. He argued that the accused has been falsely implicated in this case because the accused was intending to keep the fertilizers bags in the carriage on the roof of the bus, but the informant and the bus driver were opposing to him. He argued that the oral evidence laid by the prosecution is insufficient to hold the accused guilty of any offense. Hence, he argued that the accused is entitled to acquittal. Considering the rival contentions, firstly, it is necessary to see whether the informant is a public servant. It must be noted here that, as per Section 43 of the Road Transport Corporation Act, all directors of a corporation and all officers and other employees of a corporation, whether appointed by the state government or the corporation, shall be deemed, when acting or purporting to act in pursuance of any of the provisions of this act or of any other law, to be public servants within the meaning of Section 21 of the Indian Penal Code. The informant is a bus conductor in Maharashtra State Road Transport Corporation, Makni Depot.